Well, some experts believe that NPA performance targets and other pressures on prosecutors affect the outcomes of a number of rape and sexual violence cases that get to court and provide reasons for why others are never prosecuted. Lisa Vetten from the Wits Institute for Social and Economic Research has studied this issue. She joins us now along with advocate Wilna Lambley from Legal Aid South Africa. Welcome to both of you. Lovely to have you with us in studio. It's unfortunate that the NPA could not join us today to give their perspective, but I will rely on the both of you for a more balanced perspective on this story. First of all, not many people know that prosecutors do actually have targets, and it may sound counterintuitive to many, but you've been looking into this in a study you've just done, Lisa.
Yes, I think it's one of the interesting collisions between justice as an abstract quality and value, bumping up against, I think, a much more business, corporate-minded approach to performance within the criminal justice system. So prosecutors are required to sign performance contracts that will commit them to achieving a 69% conviction rate in rape cases. It's slightly higher for other kinds of crimes. And they're also required to spend, to roughly finalize 15 cases every month. And if they don't do that, then they have to submit their statistics every month. It has implications for whether or not they get a merit award at the end of the year, which basically will affect whether or not they get a pay increase. So it's it's in some ways a very perverse incentive, because obviously it's a way one hopes that would make people work harder, but actually it means that if people can't achieve that, they're going to look at ways in which they can achieve that and still get their performance bonus, but justice, the bigger questions, might get lost in the process.
So Wilna, talk us through how these particular factors affect rape and sexual offences cases in particular.
Well, I've had a discussion with Lisa about it. She is the one that did the study and spoke to the prosecutors itself. And from Legal Aid's management point of view, and also from the experience of legal aid attorneys in court, as well as knowing the management of a prosecution, I am thinking that there is a disconnect between what the prosecutors feel on the ground in terms of the pressure of the targets versus what is really the motive behind it. Because what you cannot measure, you cannot manage. So there must be measurement tools. But from reading some of Lisa's research, it seems to me that the prosecutors feel pressurized in staring blindly at the targets and not then understanding perhaps, or not being given the scope to explain my work. If I deviate from the target, this is the reason. And it seems that that's where the disconnect lies.
So let's talk about the kind of cases that are affected by having to chase these targets, Lisa. Just talk us through the sort of cases that suffer.
Well, I think the cases that are more difficult and more time-consuming. So the prime example of that, of course, a case where a complainant has a cognitive impairment or an intellectual disability. You're going to have to gather more evidence. You're going to have to spend more time preparing them in court. They're going to take longer to give their evidence. So I think you can see that those are some of the cases that suffer and are usually some of the first to be dropped. I think also with children, there can be questions about how long it can take to prepare children. There's also a look at what's the nature of the evidence available. So in some cases, you have often one person's word against the other. Those are not necessarily unwinnable cases, but they are much more difficult in cases where there's no relationship between the two, there's DNA evidence, the woman was injured and beaten, and possibly the community intervened and grabbed the man at the time. That's pretty much a case you'd have to be an idiot to lose. But I mean, the cases where you just have one person's word against the other and they knew each other, those are the more difficult. And those, from the analysis we've done of the bigger studies, those are the first to be dropped, along with cases where women might have been drinking. And in fact, one of the expressions the prosecutor used was to say, we call them on the way to the tavern, at the tavern, and from the tavern. Those are the cases that just don't go anywhere. So they look at particular factors and see, is this a winnable case? Is there a likelihood of conviction? If not, that might be the case that's more likely to be dropped, or it's going to be withdrawn as there being no reasonable prospects of success.
Wilna, take us back, please, to one of the first steps in cases like this where there has been an alleged rape or some kind of sexual offence committed. Of course, the police are the first point of contact, and I'm sure that police statement, that initial police statement, plays quite an important role in deciding whether later on there will be a prosecution.
That initial statement is vital. To get all the facts, to get all the surrounding facts, and to determine whether there's any witnesses, any circumstances around the incident that will support the case. You can't blame a prosecutor for not taking a matter forward if if there's not a case to take forward.
So what if that police statement is not taken properly, as it often happens in South Africa? How does that affect the eventual prosecution of that case?
This is where a lot of these issues come to play, what Lisa's referring to, because, you know, we do have something like prosecutor-guided investigations. Now, if you have your experts in your sexual offences courts, and they do get a police docket that and in these cases, these tavern cases, or whichever case, which is a bit difficult, and in which the docket that is presented is not complete. If you have time, if you have a passion, you can guide the police in saying, go back, get more statements, but go look at this, perhaps there's evidence there. But sometimes then, that is where it falls, because the police docket presented is not substantial enough. And therefore, there's not a prima facie case, because it's one word against the other with not a very good word. And the prosecutor have to make a decision. Can I take this matter to court? If I don't have enough evidence to take this matter to court, then I can be exposed to a claim of malicious prosecution. Because if I know that there was not enough evidence as the docket stands, why am I prosecuting?
Lisa, let's talk about the convincibility factor, which is, and I haven't seen this word before, but you used it so cleverly in this study. And you gave examples in US courts, perhaps, where something is considered a real rape because there were certain circumstances surrounding it, and sometimes in other cases it's not, because the case is not as convincing.
Yes, I think, so what the examples I used where there were witnesses, you don't know the person, you're injured, you have an impeccable reputation, and possibly they catch him in the act. Those are, and he's a stranger, and there were weapons. That's most people's idea of real rape. But let's say the two of you met each other that afternoon and drank together for a couple of hours and then left together. That's going to be a real challenge to try and prove, because it goes against most people's ideas of what a real rape is. And so those are the cases that struggle, but they're not impossible. You know, one can get expert testimony sometimes to try and talk a little bit about that. I think one can also look at the arguments around just the fact that you're drinking with somebody doesn't mean that you necessarily gave consent to what happens afterwards. It requires preparation, and what's also really important is that you need to spend a lot of time with your complainant preparing her. She needs to know that cross-examination is going to be hard. They're going to want to win concessions out of her. They're going to want to get her to contradict herself. They're going to want to get her to put herself in a less than flattering light. So you need to prepare someone to know that that's what's going to happen. Don't take it personally. It's the kind of game that happens in court, and this is how you deal with it. And of course, you don't coach people in terms of what answers to give, but you tell them what's going to happen so that when those questions come, it's not such a shock. Because I think what often happens to women is that they're so shocked at being called liars, or having been because you get up on stand and you might see yourself as this sort of person, and then the kinds of questions that are asked suddenly start changing how the world perceives who you are, and behavior that you think is normal is suddenly put in this very strange light, and you're made out to be somebody you don't know, and that can be a very, very disorienting experience. So you need to prepare somebody for, this is what is going to happen, and this is how you deal with it. If you don't know an answer to a question, you say you don't know. You don't try and think up an explanation, because I think very often, if people start calling you a liar, you try to think of excuses, and that's when you start being trapped in the kinds of word games that defense attorneys use. So you've got to spend a lot of time preparing. And I think this is where these time targets on how many cases you have to finish every day or every month also get in the way. Because I could actually see when I was observing trials that there'd be a tea break, and the prosecutor would run over to the complainant and they'd quickly go through her statement, tea would end, they'd call her up and she'd have to testify. And then, because the prosecutor hadn't spoken to her properly, and because it was a very poor quality police statement, the complainant would testify to things that were not in the statement. Then you've just handed the case to the defense on a platter, because then they start saying, but why are you saying this now? You didn't say that then. Clearly you must be lying.
Can I bring you into the conversation here, Wilna? Because Lisa's alluded to time frames and the difficulties within these courts sometimes, even logistically, I suppose. There are very few sexual offences courts left, but those that are operating, what are the conditions like in those courts?
See, the history of sexual offences courts, obviously, I think we're all well aware of it. There were dedicated sexual offences courts, and then there was a little bit of an upheave of it because of various reasons, which we won't go into now. However, I think the Department of Justice, the NPA, all the stakeholders recognize that this is very, very important, specifically in our country, where we have such a high incidence of sexual assault. And I think that there's a big dedication to make sexual offences courts working, and there's not very few of them left. There was almost none left. There is now a number proclaimed, and will be proclaimed further if more money is put to the purpose. However, these courts are very well resourced, some of them that works well. And they've got a paralegal type of person that prepares victims, that does a victim impact statement and prepare them for exactly this. The goal is to stop secondary victimization, which is what should happen. But unfortunately, it's not at all courts, and it's not at all sexual offences cases. And I think that if you look at the statistics between what happens at the real sexual offences courts, which are absolutely built for this purpose, with all aspects in place, versus what happens in other courts, and that's where you find the disconnect.
All right, very interesting talking to both of you. I really could go on because there's so much more to learn from you, but I thank you both so much for your time today. It was really informative speaking to you. Advocate Wilna Lambley from Legal Aid South Africa and Research Associate at WITS, Lisa Vetten. Your business news is next.